Okay. So we are joined by my colleague. For these purposes, my name is, for these purposes, Justice Nasa Konde, and I'll be presiding over the High Court of Uganda. Next to me is my learned sister, Justice Martha Kabasinguzi. Once the bailiff sits down, he will call the session to order, and then we will start. I personally wish all teams the best of luck, and see you on the other side. I hope you know how to use the microphones.
Yes.
You press to mute, to pause, then you press again to speak. Is that okay?
Yeah.
Thank
Am I
you.
clear? Am I clear? Am I clear?
You're now audible. Counsel, you can start.
Your Lordship, may it please the court. My name is Iga Eric, alongside my co-counsel, Herman Asmerom, and we are here today to represent the applicant in today's case, and that is Grace Nambuya and Samuel Katumba.
Counsel, please use the other microphone. It's much better. The other one. Yes.
Sorry, use this microphone.
It's on.
Your Lordship, Your Lordship, may it please the court. My name is Iga Eric, and alongside my co-counsel Herman Asmerom, we are here today, we appear in court today to represent the applicants, Grace Nambuya and Samuel Katumba. Your Lordship, within 10 minutes of this court's honorable time, I'll be addressing issue number 1 in today's case, and within 9 minutes of this court's honorable time, my co-counsel will be addressing the second issues as well as saying our prayers. My lords, before I proceed to make my presentation...
Counsel, do you have a right to make a rebuttal?
Pardon?
Do you have a right to make a rebuttal?
My apologies, my lord. We will reserve 1 minute for rebuttals. My lords, before I present my case, I seek leave of court to make my opening statement.
Proceed.
In a world that should have embraced their disabilities, these children were punished for it. This is a case of justice for those whose only crime was being disabled. My lords, the issue I'm obligated to address today is whether the exclusion of children into separate classes called alternative classes and the financial burden imposed onto their families violates Articles 21, 30 and 35 of the Constitution of the Republic of Uganda and directly amounts to discrimination and denies them equal access to education. The applicant submits that it is indeed a violation of the above stated laws. The applicant therefore makes 2 heads of argument to address the above stated issue. The first about the right to education, but secondly also about the right to equality and freedom from discrimination. My lords, I will proceed to the first head of argument from the applicant side, the right to education. This principle is enriched first of all in Article 20, Clause 1 of the Constitution of the Republic of Uganda, as well as on Article 30 of the Republic of the Constitution of the Republic of Uganda, read alongside Article 13 of the International Covenant on Economic, Social and Cultural Rights as interpreted under General Comment number 13, paragraph 6 to be exact, by the Committee on Economic, Social and Cultural Rights, which provides a 4-part test of what education should look like. The first test is availability. The second test is accessibility. The third test is acceptability. And lastly, adaptability. Accessibility means that education should be physically and economically accessible to each and every individual without discrimination.
Council, does accessibility encompass free education?
Very much obliged. Yes, it does. Yes, my lord.
Council, does the right to education include the right to free education or the right to affordable education?
My lord, the accessibility element of the 4-part test includes right to education that's economically and physically accessible. Under economic accessibility, that includes things like it should be affordable, but also, if need be, it should be free because everyone has a right to education. If I may proceed.
What level is education supposed to be free as a must? Or to make it a bit easier, between primary and secondary education, which one is supposed to be free?
My lord, we contend that education that's essential, education that everyone has a right to, is primary education and secondary education. There is no value, there is no measure of value to what education should be free and what education shouldn't. We contend that education in all its forms is supposed to be the applicant would rather have primary education because it's more essential. However, in case the government is able to, it's supposed to progressively realize secondary education as well, because education is a very crucial part of development and is a human right provided for under the Universal Declaration of Human Rights, and we contend that it's very important.
Proceed.
My lords, I was still explaining the tests of limitation of what education should actually look like. We look at adaptability, which basically stipulates that methods used in educating should be flexible to the needs of diverse learners and changing societies. Evidence of violation of these elements of the 4-part test is in paragraphs 8, 9, and 10 of the facts. First of all, there is a financial burden imposed onto parents that actually their children should pay an extra 1.5 million for their students to actually.
Council, just to take you back to your previous argument and in line with the argument that you're trying to make, the government has supposedly provided free primary education and at secondary level subsidized the same and only required parents to pay an additional fee to enable that students get quality education. Wouldn't the school or the government argue that they have in fact fulfilled their obligation to that extent?
Your Lordship, I'm very much obliged. To answer your question, part test number 12, element number 2 of this part test states that education should be physically, economically accessible to everyone without discrimination. By excluding some students from class because their parents can't afford tablets, we contend that this is a violation of the non-discrimination element of this part test, and we have reason to believe that this is in violation of the law, and therefore the respondent should be held accountable.
The respondent. The respondent would then argue that they have firstly provided alternative classes and not fully excluded or even excluded enrollment of students with disabilities. They have been enrolled and when need arose, provided alternative classes with special attention from the teachers and other supportive educational material. To that extent, they would then argue that they have satisfied the test of them being physically and economically accessible.
Your Lordship, if I may, when you look at the facts, particularly in paragraph 9, these children are taught with AI tablets and outdated books. There is need for equality when we are providing the right to education. Rights are inherent, universal, and independent according to Article 20, Clause 1 of the Constitution of Uganda.
Counsel, before you go there, how do you want this court to determine if we have created an appropriate balance in terms of discrimination? Should we look at a numbers game or we look at a quality game? For example, if 1,000 students are able to access education and 2 miss out, but that education that is missed out is on average quality. So do we look at the quality that is missing out or do we look at the numbers? So how do we strike the balance between 1,000 and 2 or between the aspect of the education has to work for everyone?
Your Lordship, there is no sacrifice in human rights. Everyone is entitled to human rights and they should have equal access to these particular human rights. If you say that we shall provide quality education for 1,000 and leave out the 2, it's not fair because you're violating these people's rights. You're making them feel unsafe in a society that is supposed to be their own. You're leaving them out, and as applicant, we contend that these 2 shouldn't be left out. If we are providing quality education, we should provide quality education for everyone, and if some people are going to be left behind, there should be measures of reasonable accommodation to put them at the same level as their peers that have an advantage.
Counsel, paragraph 8, and given the fact that you submitted that it's in fact a right that can be progressively realized, the head teacher of the school has confirmed that the lack of immediate funds to provide this and only required parents to chip in a little bit to help with this. I don't see how the school is in violation of providing access. In any case, they have provided the AI-generated material and even bothered to make it hard copy for the children who have any impairments to be able to access this. I'm finding it hard to believe that we should find the school in any violation.
To add to my learned sister, what can be the bare minimum in your view in terms of what the quality looks like? What is the baseline or the below mark, below which we shouldn't accept anything to go?
Your Lordship, by putting these students in alternative classes and giving them AI tablets, of which these students consent to the fact that they are dead machines to them, because Grace Nambuya doesn't have a screen reader function, making it a dead machine because she simply cannot see. Samuel Katumba cannot hear, has a hearing impairment. There are no subtitles, there is no sign language. Therefore, when they put them into alternative classes and give them these AI tablets are dead machines. What they do to supplement that is provide them with outdated material. We contend that this is putting them at a lesser level than what their peers are and amounts to discrimination. There is no equal access to education between these disabled students and the able students. Secondly, on the question about the bare minimum, my Lordship, we do not disagree with the fact that there has been significant improvements. What we demand is that the applicants actually receive this equal access to the education that has been improved. We contend that these applicants should have measures of reasonable accommodation that put them at the same level as these other students whose right to education has been progressively realized. In light to these submissions, we pray that this honorable court will hold the respondent liable for the violations of human rights that they have actually committed as per Section 10 of the Human Rights Enforcement Act. My lords, if I may be of no further indulgence, I seek leave of court to yield the floor to my co-counsel.
Much obliged, my lords. My name is Hermon Asmero, second counsel for the applicant. I'll be using 9 minutes to submit our case and make our prayers. My lord, I'll be addressing issue B that states whether the compulsory collection of biometric and personal data without consent violates the right to privacy under Article 27 of the Constitution. My lords, as a counsel for the applicant, we contend that indeed the compulsory collection of biometric personal data without consent violates the right to privacy under 2 heads of argument. That is, A, the right to privacy is protected by law, however, it has been violated in this scenario, and 2, principle of data protection and collection. Proceeding to my first argument. My lords, under Article 27 of the Constitution of the Republic of Uganda, as well as read under Article 17 of the International Covenant on Civil and Political Rights, interpreted by Committee on Civil and Political Rights, under General Comment 16, it states that to the extent which privacy includes is personal data and information. This is further evidenced in a law case in the matter of an application for enforcement of human rights by Carl Halley under Miss Cause 88 of 22. My lords, this is further evidenced in our facts, paragraph 6A, where this was done without any consent. It's also further evidenced in paragraph 1, where this survey or this pilot survey started in 2022, and by 2024, where they had the 67%, this was still going on. My lord, these are 2 years of violation of the right to privacy. My lords, imagine that. We cannot bear to have that moving on.
Counsel, at the core of the right to privacy is consent. And one would argue that consent is not absolute and it has exceptions. So in this particular set of facts, the respondent would argue that the consent here did not be obtained given the nature of the project at hand. So what would you say in line of that?
Much obliged.
Also, and whilst you're answering that question, and in line with paragraph 2 of your facts, the Ministry of Education and Sports, in fact, consented to this pilot study being done, and it's the one in charge of the education systems in the country. I therefore find it hard to harmonize you saying that there was lack of consent. And even then, the parents, by allowing or enrolling their students in these schools, give an implied consent that their students are actually supposed to be given any study material in this school. So I find it very hard for you to say that there was no consent.
Much obliged, my lords. To your question of the consent, my lord, under Section 7B of the Data and Protection Privacy Act, it states that a child is someone below the age of 16 years. And this Nakaseke school, we believe, has students that are below 16 and they can't make their decisions on their own. Therefore, the consent of the parents is very important. My lord, to your question of the ministry already giving consent, we believe and submit that as long as the child is below their parent, it's the parent who has to make the final decision. The ministry is more like a second party involved in this pilot. Therefore, consent of the child is still something very important. My lord, I proceed to our second argument.
Counsel, before you leave that point, the Ministry of Education and Sports is in charge of what's provided at schools for meals is in charge of setting the curriculum. Is your argument then saying that since the parents are the primary caregivers and therefore give the primary consent, that they give consent to all that is done in the schools? Or you're only picking a part of it that you think is not favorable?
Much obliged, my lord. We acknowledge that the Ministry of Education does all and it has got the consent. However, for this to be efficient and the applicant's right is not violated, we submit that the two must consent to have this running within the school, whereby one of the parties hasn't yet got the consent. Therefore, it infringes on their rights.
Council, to sum it up for you, is the consent required for the curriculum, or is the consent required for the data in terms of student performance as per the curriculum? Is there a need to have consent for the curriculum to be rolled out, or is there a need to have consent for the statistics, basically the performance of students regarding the curriculum? Which of the two requires consent, and who can give consent? Is it government or the parents?
My lord, both require the consent, but one requires it to a large extent, the privacy. That is why the issue I submit before you today is whether the compulsory collection of biometric personal data without consent violates the right. My lord, to your second question, the government and the parents have the right to give the consent, which in this matter, the parents haven't. My lord, I proceed to our procedures under principles of data collection. My lord, any of these principles cannot work independently. They're interdependent, meaning three of them need to be protected. A, under consent. Article 16 of the Convention on the Rights of the Child says that no child shall be subjected to unlawful interference. That is under, as well, Section 7 of the Data Protection and Privacy Act. That states no data is to be collected without consent. Again, under Article 17 of the ICCPR, interpreted by the Committee on Civil and Political Rights under General Comment 16, emphasizes consent and legality to data protection and privacy. However, my lord, we see this has been violated in paragraph 6, part A, where no consent was got. My lord, I proceed to our next principle, non-infringement. Section 10 of the Data Protection and Privacy Act says that no data shall be collected, held, or processed in a way that infringes the right to privacy. It further shows under Article 34, Clause 7, that special protection to orphans and vulnerable children should be emphasized. This has been violated because even the disabled children's parents haven't got this. My lord, to the last principle of security and confidentiality. General comment on 25 on children's rights in relation to the digital environment by the Committee on the Right of a Child, paragraph 67, emphasizes that privacy is vital to children's agency, dignity, and safety. My lord, if this is not done, it results to identity theft and emotional distress. This was got from a report of a special rapporteur on 15th January.
Has there been any harm as a result of collecting this data from the students? Any harm that's in the facts that's been caused?
Much obliged, my lord. Rumors have it that this
Rumors?
goes... Yes, my lord. And I believe we cannot forego them because according to Article 50 of the Constitution of the Republic of Uganda, if anything puts a threat to your right, then you have the obligation to go and report it. So in this case, we cannot forego that because it's a rumor.
So Council, just so I get you right, you've come to this court, no evidence, just rumors that could have been brought up by probably a competing company that wants to supply the tablets, and we should base on that to find the school in violation.
Council, as you answer that, when determining a breach to privacy, is a threat as more damaging as the actual breach? And in terms of cybersecurity, are you better off preventing a threat than dealing with the actual damage?
Much obliged, my lord. To your first question of the rumors, my lord, in this case, we provide enough evidence. However, in case we are to base on the rumors, for now, there has not been any harm. And that is why we need the parents' consent, that in case there is any harm, the parents are to report it and they are aware of this. My lord, to your second question of the data protection, we believe that at the end of it all, it's been done for the good.
Proceed.
My lord, to my argument where I had stopped, I beg for 30 seconds to make our final prayers. My lord, the security and confidentiality is something that we cannot bear to forego. As the applicant's counsel, we pray that the court makes a finding that the nature of which data was collected is a violation to the right of privacy. My lord, we make our final prayers. The applicant prays that this honorable court, under Section 9 of the Human Rights Enforcement Act, firstly, puts a measure aimed at the cessation of the continuing violation of the human right of privacy, education, and equality of children. Secondly, issues guidelines ensuring informed parental consent and protection for children. And lastly, restoring the dignity, the reputation, and the rights of the victim and the persons closely related with the victims. My lords, we so pray.
Counsel for the respondent.
May it please this honorable court, my lords, I am Sime Arnold, the lead counsel, together with Counsel Moyesa Joel, representing the respondents, Nakaseke Bright Future Secondary School. We will discuss two issues for the respondents. One in question of whether the measures taken for children with disabilities, including alternative classes and optional specialized devices, represent reasonable accommodation, progressive realization within the school financial and technical limits. I will argue this under one head of argument, and I will argue it in 11 minutes. My co-counsel will argue the second issue in key question of whether the data collection is lawful, necessary, and proportional, and serves legitimate aims such as promoting education, safety, and preventing exam malpractice in 9 minutes. After that, my lord, I make a request to start with an opening statement.
Proceed.
My lord, when students are provided with a bare minimum education, even in instances where they could not get education, the applicants think it is a bad world. We cannot stand for that world where students don't go to school. We think that is a world the respondents provide to you. I'll go then to my first issue, which talks about the education and discrimination. I'll discuss it under one argument, which is the right to education is subject to progressive realization based on available resources. Article 2 of the International Covenant on Economic, Social, and Cultural Rights, which talks about progressive realization of rights. As a state, we think the state, my lord, should take targeted steps of realizing education. In paragraph 8 of this article, it explains the introduction of this smart class AI as a pilot project. This means that it is a project no one has done before, and it is something that is in experiment. It also further explains that the smart class AI is still in pilot phase, and the international suppliers have not yet localized software for the disabled learners. This explains how learners are unable, or the disabled learners do not have the equipment to to cope up with the smart class AI. And we think it is a matter of time since it is progressively realizing the right to education in this system. The only problem, therefore, is putting these learners in a separate class. In progressive realization of education, we think it is according to Article 30, education is a right, and everyone should have a right to education. Given that education is not an absolute right, what we do as a school is provide it as a fundamental right, and bare minimally, students have to go and study. That's why we separated them and put them in a class where we gave them materials and AI-generated content. To magnitude, this amounted to the same things they were studying in their former classes, and I think on that ground it became fair. Also, we continue under this state that a state of full integration. Yes.
My problem with a school's actions are clearly excluding the results of those students from the national results that were being submitted. Yet it argues that it was still giving the bare minimum. So why were they not included in the results cause?
So according to paragraph 10 of the facts, which says that the performance reports will not be included in the school's overall statistics to avoid distorting the improved national rankings. According to Article 43 of the Constitution, which talks about general limitations on fundamental and human rights and freedoms, Clause 2 talks about public interest, that talks about what is acceptable and demonstratively justified in a free and democratic state of what is provided in this constitution. If the public interest was to fulfill national rankings and overall performance of the state, therefore we took initiative to limit these students' ability of registering them into and removing their reports into the national rankings.
Council, my problem with that though is you have a state that's required to plan effectively for all students. It cannot do that without their data and performance being included in the national rankings, because it will not know. The state will plan based on the fact that the school is providing it with students who are ably excelling.
I'm obliged, my lord. My lord, since it is progressive realization of rights and this is a pilot project, makes the idea of removing their reports a temporary idea, meaning we could still implement their reports after the pilot phase has been done and the technology system for catering for their needs has come in the second phase of implementing the pilot system.
Council, my problem with that is the school could have had another alternative, giving supplementary rankings and indicating that these are from a certain set of students who have this problem. That would have been less restrictive, but they did not do that.
They did it to generally fulfill the public interest of having overall performance and higher ranks, because the higher ranks were following the idea of initially in paragraph 6, where students had started performing in paragraph 4, where students had started performing well. We don't want to go back, because it talks about the second factor of progressive realization, that there should be non-retrogression. That is, if you have taken further steps in education to improve the education, why then should you go back down? And realizing this becomes
Council Arnold.
Yes.
While you're saying that they are progressively realizing and there shouldn't be non-retrogression from that right, it still remains the fact that, in fact, these students who you're excluding are not performing any better because of their exclusion. It's not realizing what you think that it is realizing. They're being excluded, their rankings are not being recognized, therefore the state is unable to plan to solve this because it's not provided with that information in the national rankings.
Council, to add to that, is the school more concerned with the optics of how the program looks like as opposed to how the program is doing? Because from a bird's eye view, especially from my learned sister, it seems to her that the school is more concerned with what the public perceives the program to be as opposed to what the program is actually doing. So how do you address the fears or the skeptics or the doubting Thomases that this thing is not working and you're trying to make it look like it's working?
My lord, I will address this to the right of education not being absolute. This is further extended, or the right to limit education in this case is granted by Article 14 that talks about the general limitation of fundamental rights and other rights. My Lord, of the 100% students we have in class, 98 are excelling. We cannot stop the excellence of 98 students by 2% students. What we do is that we give them a separate class where they also receive bare minimum education. We are progressively receiving some sort of education as opposed to non-education in this case. Excluding...
So, is it a numbers game in terms of 100 versus 2? Or is it access to justice? So as a court, do we look at the numbers or do we look at what is just and fair? Because
I think fairly in looking for the public interest, we would equally look at the numbers of the 98% students.
Council, the applicant's argument in that regard would be their argument and contention with the school's actions is not primarily based on the right to education that you claim, rightfully so, can be progressively realized. Their argument is that while you're trying to progressively realize this right, you're denying the children to access a right that's a political right, that's an absolute right, and therefore cannot be done away with under no circumstances.
I'm obliged, my Lord. My Lord, I don't think it is true that we are denying these students education, because putting them in a different alternative class means that we are giving them equal materials that they used before to study, outdated textbooks that they could have used to study. These were supplemented with AI-generated content, the same content that is being used in the Smart Class AI. So I don't think under this case, education is being denied to the students.
Council, address this court particularly to is it 6? Regarding the school's obligation on making sure that the students in its campus or that are under the school are not name-calling the students who have special needs.
I think students name-calling the other students who have special needs is not a problem of the school, because the school cannot take up all demands of students' bad manners. We have tried to discipline students, and this generally happens in everyday society. They try to discipline students in school, but it is by the nature of the students that they go on and call their fellows the members of the left behind class. So I don't think that is to blame.
But does the school have any obligation in that regard?
The school does best what it can in disciplining the students, but when students go further and call names to that class, it is not up to the school to be blamed for that.
proceed.
Okay, I will proceed to also Article 34. I'll proceed to Article 34 that talks about rights of children and the best interest of children. This is further extended by Article 21 of equality and freedom from discrimination. We gave them a separate class which attended to their own needs, because ideally what applicants would be arguing is that this smart class AI brought harms. I think under a system where, my lord, that smart class AI was not introduced, you wouldn't attend to the needs of these students anyway. What happens is because they will stay in a class with other students and stay at an unbalanced level. When you put them in a separate class, and that is why we have streams within schools, so that we can know the special needs of students and attend to them principally, because we want to attend to them. So these alternative classes attend to the needs of these students. They cannot use smart class AI, and therefore we give them outdated textbooks which they can use to attend to the needs of basic education. I think under this article we prove why you much more likely have outdated content. The applicants also, we pray to talk about outdated books. They are found in their need. Note that mental change, which is caused by the students, is something we are willing to concede to, because these students have caused mental change and they have caused some sort of like mental trauma to these students. But this cannot be to the blame of the school and the school. So my lord, I beg for 1 minute so that I can sum up my case.
Proceed to do that.
I think in the idea of progressively realizing education, the school also took further steps in sharing costs. They took further steps in saying that at the beginning, the parents can pay 900 and they can pay the rest. They also took further costs to tell the parents that if you want this smart class AI that caters for your children, you pay 1.5. When parents complained, the school took an initiative to put these students in an alternative class, a different class which could cater for their needs. So the school took initiatives in trying to make sure that these students still receive education. And with that, my lord, if there are no further questions, I lay down the floor for my co-counsel.
May it please you, my lord, for purposes of records, my name is Moot Joel, co-counsel from the respondent side. I'll be taking you through issue 2 of the respondents, which is whether the data collection is lawful, necessary, and proportionate and serves legitimate aims such as promoting education, safety, and exam integrity. I will argue this in one head of argument, that is the right to privacy permits lawful and proportional limitation for the public interest. In reference to Article 43, which is about the general limitation of fundamental and other human rights, it then, under Clause 2 and subsection C, it guides on how rights should be limited. It guarantees that public interests under this article shall not permit any limitation of enjoyment of the rights and freedoms prescribed by this chapter beyond what is acceptable and demonstrably justifiable in a free and democratic society. The reason as to why, my lord, we limited the rights of privacy and even consent of these kinds of children by taking out their personal information and data without the consent of their parents, as it should be, as it is guided by the rights on children, is because we are guided by this article, where we have to limit the rights, where we limit some rights to what is acceptable and demonstrably justifiable in a democratic state. We limited them not because we intentionally wanted to limit the rights or infringe on the rights, but it was because of the greater good of the public service we are giving. That is the quality of education. Education is not just a cheap principle. We need to follow up with education that is, AI infringed, AI dominated. We need to cater for the attention, for the attendance, and even to measure and even cater for things like exam integrity. That is why we take facial scans to cater to properly follow up the attention of these students in class. That is why you have to take their fingerprints to properly follow up their attendance of these classes and also cater for exam integrity.
Counsel, was that not being done before they introduced these AI tablets? The school was the monitoring attendance, exam integrity, was all that not being done in the ordinary traditional mode of education to necessitate this?
Yes, my lord, it was done, but then this is a new education system that is dominated by AI, so it would be best monitored. The attention and the attention and the attendance of students would be best monitored using the AI, given the personalization of AI tablets for each kind of student in this regard, my lord. My lord, applicants come and assert that the data protection has no harm. Actually, they agree to it. They say that the data we took should be urgent and should be to keep the urgency of children, dignity, and their safety. And they again concede that it had no harm because they based this on rumors. My lord, that's misleading. Firstly, this court should not base on rumors because those are not facts. But what we then need to understand is why this data was being collected in the first place without the consent of these parents. Yes, my lord.
These concerns that you're calling rumors are being brought up by parents who are the primary caregivers of these students, and I believe should not wait for the worst to happen for them to come to this court.
Following up on that, are there situations where consent can be excused, especially if there is no harm?
Yes, my lord. Following the Data Protection and Privacy Act, CAP 97, under Clause 7, about consent to collect, process personal data. Under subsection B, part 1, it guarantees that personal data may be collected or processed where it is necessary for proper performance of a public body or proper performance of a public body. And in this case, we are saying educational duties, it is a public body, and then this then guarantees us to collect this personal information, even limiting the rights to privacy. But then also, under the same act on data protection and privacy, under clause 8, a person shall not collect or process data relating to a child unless the collection or progressive is therefore for research or statistical purposes, my lords. We think this is a pilot study, and henceforth makes it something for research and statistical purposes, my lord. Hence, we then are justified to collect this data, even when we are limiting
Council,
the rights to this very.
My concern with you naming it as a mere pilot study is that while it's named as that, it's the same being used to grade. Because if it was just a pilot study used just for educative purposes, but the examinations that are being graded at the national level are done using the traditional way that was previously used, then we'd understand that it's a pilot study, but there is an alternative mode that is being used. But it's a pilot study used to grade students and exclude some of them.
Yes, my lord, but if I may be allowed to correct you, this is a pilot study on how integration of AI in the education system would, progress with education performance of the students. That is why it does not apply to all schools in Uganda. But then among the selected few, Nakaseke Bright Future is right. This means that it is not widespread everywhere, and so even when it is used for national grading, it is then to assess the integration or even the performance of AI integration in the education system. That is to say, the data collected under this system is to grade whether the integration of AI in the education system is doing greater or harm, my lord. Yes, my lord. I'll then proceed to the prayers we get from the team respondents. My lord, according to paragraph 5 of the facts, AI system uses facial recognitions and to monitor the attendance and attention in classes, thus promoting education safety, exam integrity, and through prevention of cheating. My lords, other instances of collection of personal data without consent is acceptable in a demonstrably justifiable in a free and democratic society. But this is for the betterment of the education system that you're having provided. Henceforth, this is a public interest. And plus, it is a pilot study. You expect imperfections here and there, my lord. Hence, there will be perfections in the later phases of this pilot study. Therefore, we pray, my lord, that this court finds it justifiable for us to limit the rights of these students and collect the data, because it is for the greater good, and even we are allowed by the Data Collection Act under Clause 7 and Clause 8 to collect this personal data if it is for education and statistical research, but then also for proper performance of a public body and in which education duties are among. My lord, if there are no submission, I pray to your law.
Applicants, proceed with your rebuttal in 1 minute.
My lords, may it please the court. Discrimination cannot be progressively realized. It must be ended immediately. Much as there was an improvement in the results attributed to improvement in the education, some students were left behind. As presented in the facts, the students were put into alternative classes and given tablets they couldn't choose, in addition to outdated books. That is very unfair. Secondly, their results were excluded from the school statistics. That is very unfair. Why do we think it's unfair? Because it makes you feel left out, as shown in the facts, where Grace Nambia actually says that she feels left out in her own school, in her own society. We contend that children shouldn't be made to feel that way, no matter the justification. There is simply no justification to discriminate a child. Much as education is important, it should be improved as each and everyone is having equal access. Secondly, on privacy, what would it take to print out consent forms and give them to parents? Much as they argue that their aims are legitimate and there is justification to limit privacy, what would it take? Are there less intrusive measures of actually coming up with these benefits that they are seeking for? My Lord, I pray that you make finding that respondent is in violation of the rights of equality and freedom from discrimination, education, and privacy. We so pray.
Thank you so much, both teams. I'd now love to proceed to my comments, and I believe both teams have done well, and as a judge, one of the hardest points is determining who deserves to win more. I believe always both teams win, but there's a team that deserves to win more. And it's always a very difficult perception or balance for me. And regardless of how this goes, I believe you've done well. You've done very commendable. You understand the law. You understand the principles. And you've applied the principles very well. I'd like to proceed to the comments. There's some improvement, especially going to the next rounds. The first one is with regards to how you perceive questions. Most of you perceive questions like we are attacking you, which is not the case. Questions are meant to test your understanding of the law and principles. So you get more marks from answering questions than from submitting what you have. So always treat questions as a conversation between you and the judge. So for this to be effective, it has to be a conversation between the bar and the bench, as opposed to a conversation from the bar to the bench. So always make sure that there's an interaction between you and the bench. If you notice that there is no interaction, then most likely we are either lost or we are bored. And that is not good for you. So always make sure that there are questions coming from our side and that you're answering them. Now, you don't answer questions with the law. Okay? You answer questions with your own understanding of what the question means to you. Then you can support your answer with the law. So first answer the question in your own understanding and then support your answer with the law. If I ask you a question and you go straight to the law, what I interpret that to mean is that you're telling me to shut up and to let you go on with your case. So always answer the question with how you understand it. Okay? Then after that, you can justify your answer with the law. For example, if I ask you, counsel, do you believe a separate room is good treatment? Your answer should ideally be, my lord, in as much as a separate room doesn't look considerate given these circumstances, a separate room ensures that disabled children get special attention and treatment in light with their condition. This is supported by the fact that the legal regime provides that government and schools should take special interest in disabled people and ensure that they get extra attention and consideration. So a separate room in these circumstances doesn't amount to discrimination. It just amounts to special attention. So you've answered my question with your own understanding, and you've backed up your answer with what the law says. In my answer, you never heard me talking about any law or any section. No, but I'm showing you that I understand your question, I am answering it, and I understand the law. So we know the law. We know the Data Protection and Privacy Act. We know the sections. Okay? What we don't know is how do you understand the law. That is what we are looking for. We're not looking at you telling us the law. We are looking at you telling us how you understand the law, because this competition is meant to help you appreciate and apply the law. It's not meant for you to showcase to us how much law you know, because we are lawyers, you're not. We definitely know the law more than you. So this is not a competition of, I know the law, okay? Another thing is, when you become lawyers in future and you practice, a judge is never wrong. And you can never correct a judge. Okay? So I had someone saying, my lord, I want to correct you. You can never correct a judge. A judge will never be wrong. Okay? What you do is to appeal a decision of a judge. You don't say that judge was wrong, no. You just say, I am appealing the decision of that judge. So you cannot correct a judge, you cannot correct the court. Okay? You're lucky we are a bit reasonable because we've been on your end, but someone else will just, from that moment, your moot is done, because they're going to fire you the meanest questions and they're going to make sure you fail. So at no point should you as a mooter think or even imagine that from that side you're better than the people this side. It can never happen. It will never happen. It should never happen. So one of the things we take very considerate in our profession is what we call collegiality. Respect of the other side. So you don't bring arrogance, you don't bring pride, you don't bring wiseacring into the profession or into the law. Most of you have heard of the problems one of our colleagues is facing, and those problems come from him having a confrontation with the bench. As a lawyer, you can never have a fight with a courtroom, a court, or a judge. With that, I'd love to give my learned sister a chance to... Another thing before I go there is always understand that when we're asking you questions, some of us, as you've seen, she was playing bad cop, I was playing good cop. So you should have noticed that whenever she was asking you a question that you don't understand, I was coming in to give you direction. So always look out for those two judges. There is always a bad cop and a good cop. So know which judge is directing you to where. So if I ask you between primary and secondary education, which one do you think should be free? If you're saying secondary education should be free, and I'm saying between the two which one should be free, automatically you should choose primary education, because it's the opposite of what? You understand? So if I give you a clue, and my clue is opposite yours, then automatically you should click that what I'm saying is correct, what you're saying is wrong. You don't persist and try to fight the process. Okay? So with that, I'll give my sister a chance to talk.
Thank you very much. I must say that this has been an extremely good round. At a moment, I thought we were in a final round because the teams are both equally good, and I think the audience can also attest to that if they are not being biased that they come from a certain school. But that being said, in addition to the comments that the chair of this moot has made, I want to comment on decorum and how you stand in court. You start off very well, and then 5 minutes in, you're putting your hands behind. They ask you a question, you bend your shoulders. All that is noticed, because while for you, you're only focusing on what you're thinking about to present, I'm looking at you, I'm not thinking about anything else. So the judge will see all the facial expressions that you make when they ask a question. They'll notice almost every mistake that you'll make. So try to give them as less chances of noticing how uncomfortable you are with a question that they have asked. 2 is still on answering questions, like he mentioned. I may not be offended because I probably don't have an ego when you say, let me correct. But people have egos, serious egos, that can be bruised by anything that you say. So be very careful if any of you goes to the next round, or even in other moods that you will participate in. Be very careful with how you address people. When I used to moot, I think I used to do this. If the judges have introduced themselves, and you think that at any point they asked a question that, or you think that they are playing bad cop, or you think that, or you're made to believe that they are not in your favor, say Justice NASA, because they will know that you paid attention to them from the very beginning, that you're aware of their position, you're also aware of their name. In more practical moods, of course, now I understand your students, you do not have access to phones. If you're facing a panel and you know what it is, if they have written or published any articles, if they have litigated any cases, if their area of specialty is in a certain line, cite the law or rely on the laws or the books that they have written. It helps. Because at the end of the day, we are all human, so it will make someone more inclined to give you probably higher marks. But whatever human and non-offensive mode you can use to soothe a judge's egos to make them inclined to believe in your argument, or even, because if you call out someone's name and they were just seated back, they'll definitely lean in and try to listen more to you. So maybe you can use that in your other rounds or in the future. And then lastly is on rebuttals. There are very, very key contentious things, or there are always very key contentious things that come up in a round. You have 1 minute of rebuttal. Attack specifically that. Because at the point of rebuttal, everyone has already made their case. It's only left between deciding if it's a final, who takes it or who does not. So try to use that in the next rounds or in the next modes. Otherwise, I wish you the very best, and thank you for a very good round.
That is all from us today. Ideally, we would say court is adjourned, but we're not in real court, so you guys can leave at pleasure, and I hope it has been fulfilling for all of you, and I wish you the best, and looking forward to seeing you, as always, on the other side.